September 29th. Policy and Procedure Committee. Call the roll, please. Amanda?
Paul,
Here.
Barr,
Here.
Awful, here, Sure,
Here. We have a motion to approve the agenda.
so moved.
We have a second.
Second.
All in favor, say aye.
Aye.
Are there any public comments this morning? Seeing none, we'll go to the committee chair reports. Start out with Mrs. Awful on the health committee.
Yes, we will have our normal reports on with animal control.
Mr. Bard, tax, zoning,
The committee heads will make their regular monthly reports, and the committee has a rezoning, rezoning deal to approve,
rezoning, huh?
or zoning.
When is the zoning hearing?
It was last Tuesday.
It was,
Yeah,
and they voted to approve it.
yeah,
My goodness.
yeah. They kicked it up to us.
Yeah, okay. Mr. Rawls, highway committee.
We have letting on the box installation that we had resolutions for last month. Anything else?
That's regular reports other than that.
And our regular claims.
Everything else is quiet on the highway front?
Yes.
Good. All right, chairman comments. I guess I'd like to report that, I've been to 2 flood meetings this past month, one in Rensselaer for the Iroquois River Conservancy District in Indiana, and then last Friday we were over in Culver, Indiana for a field meeting with the KRBC, where we had a chance to look at some of the work that's been done over there. It's very impressive. One of the things that really impressed me was the fact that we've heard for a long time about all the sand that is over in Indiana. And I have to say that once you experience it, you have a much better appreciation for exactly how serious a problem that is. We're walking along the riverbanks is akin to walking on the beach at a lake or at the ocean. And how that sand has even stayed where it is as much as it has is almost a miracle. But the amount of sand that keeps getting washed down the river is something that is just a huge problem, and it affects us. It affects the Kankakee River, but it also affects us because we have to flow into the Kankakee River.
Yeah.
So.
Yeah, well,
The other thing that impressed me greatly was that among the work that they've done over there, following the recommendations of the reports that were presented, you can see the flow of the river, and the main current is right in the center of that river. There's almost no current along the banks. And even though there's a lot of turns and banks in the river where we were at, it's just amazing how they've got that current staying in the center of that river. I imagine when there's a flood, it's getting by the door because the water's up high and it's difficult to control, but under normal conditions, they've got that current really well under control. And I think that's something that we could learn a lot from in this county if we ever woke up and decided to do something with our river as well. I guess along that line also, I should report that there are plans underway for March 10th of next year to hold a flood conference up in Kankakee. And it's gonna be supposed to be an all-day deal, pretty big thing. They're inviting quite a few people in. There was a Zoom meeting on Tuesday of this week that I participated in, but some of the plans were being formulated and so forth. So there'll be more to come on that as as it takes shape. Angel Crawford has volunteered herself to be active in that endeavor. I guess between Angel and myself, that's right now what the representation from Iroquois County will be, but there'll be people from Indiana coming over as well as people from Illinois. We're hopeful to get a lot of the legislative people to participate and attend it and so forth. So that's where things are at with the flood situations.
Yeah, I guess Arundel Park, they're gonna be dredging out around the dock and everything because they
Well-
can't even put a boat in.
Well, you know, part of the deal is that Kankakee is represented in the Illinois legislature by a Democratic senator.
Yeah,
So he's brought $7 million in there that they're using to purchase equipment for that.
yeah,
Iroquois County is represented by a Republican senator.
Yeah.
And I think that.
that says it all.
I think that pretty well describes the difference between the two counties and some of the activity that's going on. So I would say also that probably we might be well served to encourage our senator to be more active.
Yeah.
I think he's been absent too much on flood matters in this county. That's a personal feeling, however, I don't wanna get too deep into that. Okay, we'll move on to our friend with the EMA and hear his report. And Donnelly has a huge report because he hasn't been here for a while.
I've been doing nothing, I've been sleeping, and that's it.
Playing with that cute baby.
No, I actually have not been sleeping on that account. Anyways, what we've been focusing on, hazard mitigation. The feds got back to the state. Last I reported to you guys, I said we're waiting on the federal government. Because the application I made was to the state, and the state combines my application with others and submits that to the federal government. Took a while, but the feds got back to the state, and the state's come back to me, and I need to make more revisions. I'm working with the state on making those revisions. So hopefully we'll get those done, and once it gets approved, then I will submit a request for proposal, publish that, and then hopefully get in proposals from contractors to start the process of rewriting the hazard mitigation plan. HyperReach is our mass notification system that EMA purchases. And I got HyperReach to conduct a couple of virtual trainings. So I hosted trainings where I had some fire chiefs and the Iroquois County Sheriff in, and we trained them how to use it. So that way it's not just me that's able to publish emergency alerts to people. Wanted to get other authorized individuals in on that. So I think I got maybe another half dozen people trained on that. A couple months ago, the National Weather Service had a handful of radios that they received through a federal grant that they needed to get out to schools. So they gave me 5 of them, and then I was able to give those out to local schools.
What kind of radios were they?
Just regular NOAA weather radios, the same kind that you can find in the store. Midland brand, they're probably $20 or $30 in a normal store. Sitting right there, it's a great alerting tool for all hazards, weather and otherwise. Just a nice little thing. It just kind of passed through my office. Have to get them out. Let's see, IESMA. I'm part of a mutual aid organization called IESMA, Illinois Emergency Services Mutual Aid Association. And I used to serve on a subcommittee for that called EMAT. EMAT specifically is for providing is the committee that governs teams of emergency managers that will go across the state to help emergency managers in need, something I've utilized in the past. I'm no longer on that subcommittee. I am on 2 other subcommittees with IESMA now. One is the legislative subcommittee where we review pending legislation in the state and the federal government, how that impacts the emergency management community. And also the subcommittee that looks at state grants, specifically EMPG, which month's half the salary for EMA, and also HSPP, something that your quick ed doesn't apply for. But anyways, so I'm no longer serving on one subcommittee, I'm serving on two other ones. So staying active with the Mutual Aid Association. I attended the annual IEMA training summit in Springfield in early September. That's something that I usually go to every year, but haven't since 2019 due to COVID, due to the pandemic. So this year they resumed it. Was there for 3 days, and some topic at training summit, there's always the general sessions and there's smaller sessions, you can pick which ones to go to. And general themes that I learned about this year was cybersecurity, big push for cybersecurity and how it impacts infrastructure, so on and so forth. And also cybersecurity in terms of healthcare agencies and also local, county, or municipal governments. And things that have happened in recent history to local county governments and state governments and municipal governments and also healthcare entities. And also cybersecurity attacks are happening almost every day on infrastructure. What that means, how we can get prepared. I've been bugging a couple other, after I came back from the conference, been bugging Jill and Brianne about what we do for cybersecurity and irritating them, trying to figure out where we're at, so. Yeah. I attended a session about the 50-mile radius planning efforts around a nuclear power plant. Portions of Iroquois County are within 4 different 50-mile radiuses of nuclear power plants. Let's see if I can list them. DeWitt County, Braidwood, LaSalle, and Dresden. Nuclear power plants, portions of Iroquois County are within the 50-mile radius of those nuclear power plants. Now, the 50-mile radius is not as dangerous as the 10-mile radius. It's what's called the ingestion pathway. So within that 50-mile radius, it could be, if there was ever a tragic incident at those plants, that food sources within those areas would no longer be good, or they would be dangerous, especially in a farming community. Then we have to start looking at planning efforts for that. So, talking about that, and the state may be hosting future exercises about that. We will continue to tune in. I've talked to you all before about the 32 FEMA core capabilities and how EMA is being required to test all 32 core capabilities. How difficult that was going to be, especially since something we never even addressed, like forensics and attribution. Why would EMA have anything to do with that? Well, Illinois Emergency Management Agency has backed down from 32 and is now pulling us to 18. So that's good news because, as I reported to you guys before, we're gonna have a hard time getting all 32 core capabilities tested every 4 years. And if I wasn't able to do that, then EMA would lose its accreditation, and that means no more training. So, good news is they trimmed it down to 18, that makes it more manageable. There's a lot of work to do to be able to accomplish that, but it's still good news. In addition to, on that note, how we assessed all 32 core capabilities and our threats and hazards was through a tool called the ILCAT. I showed it to you before. It was a massive 101-page PDF document. I'll report it to show you. They've changed how to report that. It's probably good, but it's no longer on a regular PDF document. It's now through a web system with this day called Web EOC. Anyways, so the format changed there. Hopefully it'll be good. I need to get that done soon, probably within the next 6 months or so. Anyways, looking into the future, I'm working on getting a few exercises and trainings planned over the next 6 months. Communications, cybersecurity, aircraft, those are the kind of things I'm looking at. In addition, throughout Region 7 of IEMA, that's kind of the surrounding area around Champaign, which we already included, we all take turns hosting a monthly STARCOM radio drill. My turn is next month, on October 4th, so we'll be doing that. And at a regional meeting that was recently in Roanoke, Naima Region 7 regional meeting, it was explained by Naima that while the EOP, as we were told the EOP, the Emergency Operations Plan for the county, one of my basic duties in maintaining, is would be due March 15th of next year. They've upped their timeline and said, actually, we want it December. So I gotta get cooking on that. And that's what I got. Any questions?
Are they gonna send you down to Florida to help with the
Yeah.
recovery of it?
The answer is 99.9% sure, the answer is no. But I do wanna make it clear that that is possible, and it has happened before. That process would happen through something called EMAC, where one state, Florida, puts out that they need assistance from another state. And other states, like contractors, bid on it and say, this is what it'll cost you for us to send people your way. This is what they've done with Louisiana, Texas, and New York before, and Florida. So I don't think it's likely at all, and even if it were, then, even if the state of Illinois were to want to go provide assistance, they would likely go with other emergency managers that are part of EMAT or other emergency management teams that they already have formulated, which I am not part of, because I knew I do not have the time to be able to volunteer for that, so unlikely.
Okay, anyone else have any questions?
Busy guy.
I told you there'd be a long report today. Thank you, Eric.
Well,
Thank you.
as I go back to sit down, I'd like to remind you that flu vaccines are available, as well as updated COVID-19 boosters at the health department.
Okay, next, we're looking for an update on the sexual harassment.
Well, we are 67% complete. Just again, I will send out the information after the meeting today with the link for everybody to complete it online. I do need a signed certificate sent back to my office before I mark it complete. As usual, there's computers in my office. I'm more than happy to host a group showing in here using the AV system. And that's about it.
Okay, thank you. We'll move on to a discussion on the county personnel policy manual. We got it up there on the screen. I know we've gone through a little bit of it already. However, I'm not sure that we all remember everything we've done or that we covered everything, so I thought maybe today we'd start at the beginning again and see if we can hustle through some of it, so. First question is, can everybody see the screen from where they're at? Can read it? We need to bring it closer. Glasses on, see if I can see it. It's over there somewhere. Notice on the very first cover page, there's a sentence that's underlined down there that talks about anything in the manual anything that's covered in a union contract supersedes what's covered in the manual. And that statement I found is repeated several times, numerous times throughout the book, so I guess we understand what it means. Does anybody have any question or problem with including that? In other words, everything in this that we're gonna see today where it's underlined, this lady that reviewed this, the lawyer up north, this is what she's recommending that we change and add into the book. She also has some things that she drew a line through that should be removed. And she has some recommendations that will show up for other things that need to be changed. So there's some things in there that I think we need to pay particular attention to. One of the things that I expressed in the past was the places where there's uses of the words like reasonable and at our discretion and so forth. And to me, those are not good terms to have in a policy manual because there's so much room for individual interpretation. And to me, if it becomes a problem, then it goes, the only way you can ever resolve it is to go in front of a court of law and they're gonna try and figure out what's reasonable. I don't wanna do that. So I'm not sure what the answer is, but I don't think we had the word reasonable in the book before. I'm not excited about putting that in there, so.
Yeah, I tend to disagree, and I'll tell you why, because, when you say reasonable, you are not committing to a specific event, so, then it would be up to their attorney to prove that you're wrong. If you have a specific wording in there, you're basically saying this is what your limits are. And that in our attorney's, view, would be easier for you to fall into an area where they would be able to prove that you've done something wrong because you specified, you've gotten more, direct instead of leaving it as reasonable. And that's the part where I had conversation after we had our meeting. And I asked the same question, there's a lot of concern about there being the term reasonable and having some leeway in there. And that's the description that they gave me, was that the more that you put in there, the more they can pick at you with. That's their reasoning for using the word reasonable.
Okay, so where the word reasonable is used, does it say, maybe we need to look at it, but does it say, what is reasonable in our view? In other words, it's up to us, what is reasonable from our point of view or our judgment as to what's reasonable.
I believe it's gonna, when it gets to that point, and I believe when you get to that point, it doesn't matter what you have in there, you're gonna have the attorneys, are going to be the ones discussing what's reasonable and what's not reasonable. Or if you have direct language in there, then you've either not lived up to your part of that direct language or that you have. And so, I think they're just trying to protect the county, as in not putting stuff out there that another attorney can come after. That's the direction that I was given.
So then the attorneys are the one that decides what's reasonable.
What would be reasonable by what you have in your manual.
I don't care for that at all.
Well, and I guess part of the concern that I would have is that the purpose of this manual is to provide specific direction, not only to the employee, but also to the supervisors. So that everybody knows exactly whose responsibility it is to do what and who has authority to do what and so forth.
Sure.
I think that's kind of been the mindset that we've had in going through this manual in the past, is to try and be clear and specific as to on the different topics, as to what, behavior is expected and what, so forth, so. The more general we make it, I think it just muddles the field for the supervisor, not knowing, well, can I do this or not? Am I gonna get in trouble if I do this kind of thing?
And according to Myron, it gets on to the lawyers, and then they're the ones that start getting into the mix.
We have had incidents here, fortunately not that often, by far and away the majority of our employees are reasonable. But by the same token, we have had some incidents, in fact, we just had one recently where, we had an employee that I'm not even sure what transpired in the employee's mind or motives, but the employee was hired and never really showed up for work. And what transpired over, was it a month or so, Amanda? That's the one that Eric is involved with? I mean, to me, it just illustrates the fact that I think we need to be, in this day and age, we need to be a little more careful and concise in what we're trying to accomplish. If we're gonna have a manual at all, it's got, I guess we need to try and better understand perhaps what the purpose of it is and how it's to be used then.
I mean, at the end of the day, it's the board's decision what they wanna put in the manual. I mean, it's,
Well,
your recommendation only is the insurance and their attorneys. And you've been through the whole manual with a risk manager who's completely different than an attorney. So he's giving you advice on what he would see in the labor part of it, you know, that's his advice. Then you went through that whole policy at least once with him, then you put it on the other side of the fence and to an attorney's hands, and then they made recommendations of what they thought would be better if it got to court. So I think you've had both sides look at it, and then, I think at this point, you're looking at whether you approve of what they have recommended or not. Am I right?
I think so, and I think that's the reason for the discussion and trying to be a little bit introspective into it, as well as trying to keep in mind what the purpose of the book is, and
Sure.
that's why I'm saying, you know, if I'm a supervisor and I'm seeing mixed signals, why it's a bit confusing, and I don't think we wanna, as a county board, I don't think we wanna lay that burden on the supervisor. We wanna try and make their job, you know, as easy as possible when they, so far as how they handle these kind of things, so. So anyway, let's see if we can go through and see where we go. I don't guess any of us have a problem with including that statement, because that is exactly what's supposed to be. I guess what I would like to see us do today, if we can, as we go through this and come to these different things, the ones that we want to approve, let's see if we can make a record of it so that we can proceed through the whole book. Know exactly what changes we wanna make, what things we wanna adopt and what things we don't want to adopt. And then we can present that to the board, in our monthly report, I guess. That makes sense? So let's, on the first page, we'll adopt that statement that's there, okay? So let's- What do we got on the next page? There's a place on the next page where we have the same statement repeated. I can't really see it clear enough from here, but
The comment is that, the specific sentence, all county employment positions not expressly exempted from coverage by these policies and procedures shall be subject to their provisions. The comment made is just that should be a separate bullet point, so,
but isn't there something underlined on the page as well?
yes, that also, you're correct, that is the same as on the first page, it just says in the event of conflict between the provision of collective bargaining agreement and provision.
Okay. Anybody have any issues with adopting any of that? We just need to move that one statement into a regular sentence and leave it, the wording stays the same.
It's just the
Nothing there. So what have we got on the next page?
The only thing added on page 5 says, under policy, it is underlined that in case of medical emergency to dial 911.
I don't think there's any problem with that either. Anybody have any objection to including that?
Alright, so page 7, accommodation for employee with disabilities, the comment is to, there was a sample policy attached, basically it has an obligation to reasonably accommodate employees with medical or common conditions relating to pregnancy and childbirth, as well as an obligation to provide reasonable accommodations for firmly held religious beliefs. So in reading through this, under policy, they cross out whenever feasible. And so the sentence then becomes, Iroquois County will provide reasonable accommodations to qualified employee with a disability which enables that employee to perform the essential functions of the job and to enjoy the same benefits and privileges of employment as are enjoyed by the employees without disabilities, so long as the accommodation does not result in undue hardship on the county.
So we come up with that word again.
Well, reasonable was, we have reasonable used in our prior
Okay,
one as well. That,
Mhm.
I mean, that, in my mind, doesn't diminish the question as to what that word means, but I guess what Byron is suggesting is something that makes a lot of sense.
so we hope.
But
we
it
don't-
doesn't say reasonable and who's, you know, who's determining what's reasonable.
Yeah. So we hope it doesn't get to the attorneys.
The only thing is under responsibility where it talks about under B and C, I guess it is, if it's the same as what I'm looking at here, that it's the responsibility of the department head and supervisor as well as the county board to make those reasonable accommodations, so. I guess that,
So are the department heads and supervisors aware of the reasonable accommodations?
Yeah, they should have to be.
They part,
They should have to be. So under responsibility, it states employees should notify their supervisor of any need for reasonable accommodations. And B states it is a responsibility of department head or supervisor to communicate with employees regarding this policy where circumstances place the department head or supervisor on notice that a reasonable accommodation may be required and to evaluate requests for reasonable accommodations and report to the county board chairman. So reasonable, so the employee notifies the supervisor or department head that there needs to be an accommodation. And then once that accommodation is decided to be something that is in place, then the department head or supervisor is to let the county board chairman know. C states it is responsibility of the county board to make the reasonable accommodations for the qualified individuals with disabilities. When doing so will not cause undue hardships for the county.
again, there's a lot of judgment there.
yeah, like what's undue hardship for the county?
That also fits into the definition of the word reasonable.
Yeah,
If it's a hardship to the county, we may not consider it to be reasonable. I think that a lot of this is something that, in most cases, the supervisor is not gonna wanna hire somebody that requires anything that might border on the area of being unreasonable or being a hardship. I think the place where this comes into play is when you have an existing employee that maybe experiences a medical event that
Yeah.
requires them, or renders them disabled in some respect, and then requires some type of accommodation in order for them to continue their employment.
it's been employed for a period of time and,
Well, and it's hard, I mean, whether it's, they've been employed for a year or 20 years.
Yeah, yeah.
Probably doesn't make any difference, you can't discriminate that way.
accident or some type of medical thing.
But nevertheless, you know, events happen, it could be a health event, it could be an automobile accident, you never know what
Add
the
on to this.
event might entail.
Where do you get it though?
Oh, yours doesn't have it on there. I can make you copies.
You never know what the event might entail, but yet, I guess it's up to us and the employee to try and work all that out.
Right,
I know we have had situations in the sheriff's department where some deputies have had medical situations that have rendered them unable to continue to serve in that capacity, and there's been settlements reached with them as well as, what's the thing we get from the state? On unemployment, what's the other insurance that we have? Workers' comp.
okay,
That's part of what's workers' compensation. We've had a couple of instances where we had employees, in fact, just recently, we had, I think, reached a settlement with one.
Yeah.
employees over there that was off work for a couple of years. And we were not able to accommodate his disability in a way that would make him productive, so an agreement was reached. So I suppose that's a door that's open there, even though it isn't specifically stated. But to me, it's implied if it's a hardship for the county or unreasonable, then you have to make some kind of an agreement or settlement with the employee.
Right.
So, I don't know that that doesn't need to be included in any way, I suppose, does it?
I would say no,
Mhm.
but,
I mean, that's, you know, if you have a situation and you cannot, if it is determined to be a hardship to the county,
Yeah.
what do we do? Do we terminate the employee in some way? Do we reach a settlement with them? You know, I suppose every situation is different.
right, it could go either way. I mean, if they can't perform their duties as described, and you have made concessions to a reasonable, and they decide that they need something that causes a hardship, I would say that the only option would be dismissal.
And keep in mind, the point of this manual, you know, it does set out guidelines, but in my mind, the main key is department heads and supervisors have to document everything.
Right.
Because the documentation is what the lawyers are gonna use
Right.
in order to fight our cases. And if there is no documentation, they have no case. And this is basically a guideline, it's not set in stone, you know, rule by
Okay.
rule book.
And I agree with that, but I think that's something that needs to be put in a statement that accompanies the manual that's given to the department heads and supervisors to make sure.
Well, and it
Yeah.
does, there are several places throughout this handbook that provides templates for them to fill out and for
Right.
them to document,
Well, a
but it
separate,
needs to be
a
followed.
separate statement
Follow.
carries a lot of weight, I think. I would
That's
think that's. You know, how many people have actually read through everything in this book? Let alone be totally familiar with it. There's a lot here.
Sign them.
I mean, again, it's one of those things, they're grown people, they're in charge, it's up to them to make that decision. I've read through this manual several times. When a situation occurs, we refer to this manual, and by we, I mean Amanda and myself, and we try to follow it as close as can. But in speaking of recent events, documentation, we started documenting from the day that we got contacted with an issue, and we documented throughout, and that's what we have to back up what we've done for the process. And you know, hand-holding is one thing, but department heads have to be held accountable for not following through with the documentation process.
I agree, I'm just saying that maybe you know, when you give them the finished product, if you have a little memo that underlines some of that might help.
Do they have to sign? Do you have to have?
When I took over, I added a sheet whenever people get employed, that they are aware that each office has a copy of the employment handbook. They are also able to request a copy of that handbook from their department head or supervisor, or they can come to Amanda or myself and request a copy if they're not comfortable asking them to do that. So yes, we have started having everybody sign off that they are well aware that there is an employee handbook and that they are able to either look at that or receive a copy of their own.
So
Are they required to read it?
are the supervisors aware that when a problem arises, they have to start a paper trail of documentation so that it is down in black and white with what they've seen or reported?
They should be, Roger. I can't speak for all of them because again, I'm one of the newer ones. I've only been here 4 years, but I mean, common sense.
Well,
You're
yeah,
in charge of a department, you should know that documentation.
you should
is
know,
key.
but
And after all of the recent events in the 4 years that I've worked here, I think that point has gotten well across.
okay.
Okay, Mrs. Silver, you had a comment?
Well, I was just gonna say, ever since this policy manual was adopted, I know in the clerk's office, it's something that we require all of the employees to sit and actually read. We watch them
Good.
go through the actual manual. I'm not saying that every other office is doing that, but the board went through the process of making this manual. They need to read it. I mean, it's in their best interest also. We also make them read their union contract, so they have, I know you guys, do you guys have copies of that you give out? But their union gives
No.
out copies of it, but we make them read that, so they know what they have the ability to do, and we know that they know. So it, like you said, it's the department had taken the responsibility, but just so you guys are aware, definitely in our office, our employees all are forced to at least flip the pages. I don't know if they read the words, but they flip through the pages of it, so.
Yeah, and as far as an HR department where Amanda and I are concerned, as long as they sign off that they are well aware of that and that it is in their office and it is up to their department head to let them see that, that's covering the HR part of it. As far as each department doing free, and that's fantastic, but we don't have any control of whether or not they're doing that. I just need them to sign off that they know it's available to them and out there.
The manual exists.
Okay,
And as far as union contracts go, we don't do anything with union stuff, we just tell them,
Discuss union with.
no, we are just, we basically tell them somebody will be in contact with them.
okay, on this section on the disabilities, have we covered everything that's up there, and what do we wanna do with it? Adopt all of the recommendations?
I don't know what they are.
So I can read them again. Under policy, it states Iroquois County will provide reasonable accommodation to a qualified employee with a disability which enables that employee to perform the essential functions of the job and to enjoy the same benefits and privileges of employment as are enjoyed by employees with disabilities, so long as the accommodation does not result in undue hardships in the county. Is this something you wanna keep? I'm seeing some head shaking. Under responsibility, it's crosses out A and it states employees should notify their supervisor of any need for reasonable accommodations. Is this something you would like to keep?
And I had a question about that, because I guess what we're saying is that on the one hand, it's the supervisor's responsibility to be aware of this, and then we're also saying that the employee has a responsibility, so there really is we're saying there's a mutual responsibility for both parties to notify one another, so it's kind of like a double check that it does get taken care of, so I think that's probably good.
Okay,
That's fine.
and then letter B, it states it is the responsibility of the department head or supervisor to communicate with employees regarding this policy where circumstances place the department head or supervisor on notice that a reasonable accommodation may be required and to evaluate requests for reasonable accommodations and report to the county board chairman. Any questions there?
Okay,
Is that something you wanna keep?
Yep.
Okay, C, it is the responsibility of the county board to make the reasonable accommodations for qualified individuals with disability when doing so will not cause undue hardship to the county. Is this something you wanna keep? Okay, under procedure, the employee requiring reasonable accommodations will provide the department head or supervisor with a request for the accommodation, or the department head or supervisor may initiate the process when they know that the employee has a disability, know or have reason to know that the employee is experiencing workplace problems because of the disability, and know or have reason to know the disability prevents the employee from requesting a reasonable accommodation.
Sure a mouthful.
Like, wow.
Let's keep it simple.
Wow.
somebody interpret that a little bit?
Yeah.
I mean, to me, it's that, it kind of was saying, what I just said a minute ago, that both parties have a responsibility to make the other party aware of the need. Does it take all that verbiage to say that same thing?
The lawyer says it does.
Oh, that's a lawyer talking there, okay.
Yeah.
There you have it, all right, okay with me.
Okay, B.
I guess one comment I would make, you know, when the lawyer is making these comments, is this lawyer speak, or is this something that intended for people to understand and comprehend on a, you know?
Like Myron has said before, we had the risk manager and the lawyer look at it.
Yeah.
This is basically just saying that if you know they have a disability or expect that they have a disability, make sure that a reasonable accommodation is being offered. B, the county board will ensure that the reasonable accommodation is implemented unless doing so would result in undue hardship to the county. Keep that.
That's pretty simple.
Alright. This is page 8, attendance. So the first part under purpose states employees have the obligation to be at work during scheduled hours and may make every effort to do so. Regular and consistent attendance at work is an essential function of every position in the county. Is that okay to keep?
Yeah.
The next comment is under policy. It states excessive absence, 3 occurrences of absence in a 30-day period or 6 occurrences of absence in a 6-month period is considered excessive. The time periods of 30 days and 6 months begin with the first occurrence of absence. Either will be cause for a step in disciplinary action policy. Any evidence of pattern absence will subject the employee to the disciplinary action policy. The comment here is, I do not recommend policies that set a limit on number of sick days that can be used. Penalizing an employee with a legitimate need to use accrued sick leave can result in liability. Instead, consider requiring an employee to provide healthcare provider verification of the reason for absence if abuse of sick leave is suspected.
So they're asking for a doctor's note, right?
Yeah.
Basically, yes.
Yeah.
So instead of, so what they're suggesting is we take out the time increments, so
Yeah.
if we take out the time increments here, then it basically, this sentence should state here then, I'm trying to think. An employee may be asked to provide a healthcare provider verification of the reason for absence if abused sick leave is suspected.
Some doctors will put a date when they are to come back.
So what is suggested is that under excess absence that we go ahead and strike that whole paragraph here and put what is commented here, that an employee may be asked to provide a healthcare provider verification of the reason for absence if abuse of sick leave is suspected.
If
Is that
a
okay?
note is not required whether you think it or not.
But you're covered by if it's suspected. So are we okay with striking that paragraph and just putting in the recommendation of an employee may be asked to provide a healthcare provider verification of the reason for absence if abuse of sick leave is suspected?
I guess so.
Yeah.
I mean, what we had before was trying to be specific.
If you have a,
We can't
something,
be,
like-
we can't be specific, I suppose, I mean, what we have here really didn't prevent the supervisor from doing that, asking for that anyway, I mean, that's always been an option.
Yeah, I see.
so if we get healthcare, which would basically be a primary care physician, why?
I would say that's fine, you know, some of these kinds of things, you know, if we adopt them and we find that they don't work, down the road, we can always go back and make changes. There's nothing that says,
amendments.
you know, there's nothing that says once we do this, that we're stuck with it for 10 years or some period of time.
Okay, the next paragraph states pattern absence. We are adding in this sentence. Employees who are suspected of abusing sick leave may be required to provide a signed verification of the reason for absence from their healthcare provider.
Yeah.
Alright, next paragraph. Excessive absence caused by health may require a medical leave of absence. It is suggested that employees in ill health take appropriate action to be at work consistently to avoid damaging their record. Now, the comment is, I do not recommend this in light of COVID. Employees with COVID symptoms should not be encouraged to come to work. Instead, you could advise employees that FMLA and ADA benefits may be available to them for qualifying reasons. Okay, so what it's basically saying is strike the sentence, it is suggested that an employee in ill health take appropriate action to be at work consistently to avoid damaging their record. And replacing that with employees, or that FMLA and ADA benefits may be available to them for qualifying reasons.
If somebody,
FMLA and ADA,
yeah, if somebody is,
family medical leave and ADA.
Okay.
Yeah.
Okay.
Why can't I think of it? Anyways,
if you have a time period like we had with COVID and some employees are allowed to work from home, they're at work, are they not?
Yeah.
Does the definition of at work mean you have to be physically present in this building? When Eric goes to a conference someplace, he's at work. And somebody's working from home,
Might be a play.
I'm at work, you know, I mean, I do a lot of work for the county at my home.
Yeah.
I'm at work. I'm not playing golf or fooling around.
Sure.
What?
okay, so are we in favor of excessive absence caused by health may require a medical leave of absence? And then adding in the statement FMLA and ADA benefits may be available to them for qualifying reasons?
I guess so.
So the next sentence, no call, no show, failing to call and failing to show up for work, one occurrence may be considered an immediate voluntary resignation of employee's position. The comment is, I recommend first determining if there was a legitimate reason for the no call, no show. Also, some employees have due process rights due to union, or being contractual employees. Employees with due process rights should not be terminated unless they are first provided with written notice of the charges against them, an explanation of the employer's evidence, and the opportunity to contest the charges at hearing.
Well, I mean, you don't know exactly why they couldn't call, could have been their phone broke or something. I mean, that's pretty. Go along with that.
I wonder if we left it the way it is and changed the word is considered to may be considered.
It does say that, failing to call and failing to show up for work, one occurrence may be considered. It already states
I got an older version here.
Okay.
That is it, but when it says maybe, you're giving the option.
Giving some leeway.
I think that's why you changed it to May from
Yeah.
this.
So we wanna leave that the same?
Everyone has a cell phone. I mean, if you start into work and you get stuck in a snowdrift, you can call in.
I would be very surprised if a supervisor has a valued employee and he had this situation that they would go to that extent without first trying to determine what the reason was or problem was. And
What if they
certainly
have a
there can
medical
be,
event? Yeah. What if they had a medical event, you know what I mean?
Right.
Like a heart
It could be
attack or-
medical
Right.
event, it could be.
I mean, they're not gonna just not show up for work and you're gonna go, okay, they're off, they're done,
Yeah.
you know,
it could
you're gonna
be
find
an
out.
automobile accident, it could be a snowstorm where they got
Death
stuck
in
in
the
the
family.
snow, I mean,
Yeah.
there's all kinds of reasons that could account for something like that, and I'd be very surprised if we have a supervisor that would just go right ahead and
Yeah.
terminate somebody without looking into it.
Have his walking papers for him the next time he comes in.
So we're gonna leave that in there as how we have it.
I say so.
Okay, so failing to call in 2 hours before the start of the shift or workday, one occurrence is considered unacceptable and will be cause for a step in disciplinary action. That comment is, she first recommends determining the reason that the employee failed to call in. So,
It contradicts the one right above it though, doesn't it?
no, it's saying the same thing as the one above it, that they're, both of her comments are saying that first you need to decide, or first you need to determine the reason that the employee failed to either no call, no show, or not call in.
No, but what I'm saying is if you fail to call in 2 hours before the start of the shift, that's the same as no call, no
Right.
show.
The only thing that I would suggest is changing that will be
Right.
caused to maybe,
That's what I was just gonna say. Cause it
because then
will
it
be-
gives you the option to find out.
Yep,
So-
I agree with that.
Yeah.
Okay, so occurrence, each individual day or days absent in a row is considered one occurrence. For example, a 3 consecutive scheduled workday absence is one occurrence. The comment is, she does not recommend occurrence-based absent policies.
Doesn't say why.
Mm-mm.
Okay, explain this again, I understand.
Okay, so what she's saying is we have in there, in quotation, or in parentheses, one occurrence, she's recommending that we take out that one occurrence. So it would just say each individual day or days absent in a row is considered. Let me think here. So she's saying just get rid of that whole sentence and it altogether, so it currently states occurrence. Each individual day or days absence in a row is considered one occurrence.
Right,
For example, a 3 consecutive scheduled workday absence is one occurrence. So she's saying get rid of that altogether.
I guess I would agree with that because I don't see what that sentence accomplishes.
Right.
The sentences above have already talked about how you
Right.
deal with something like that, so.
So moving on. There's no changes to page 9. Page 10 is at-will employees. So under purpose, the recommendation is unless your employment is governed by a collective bargaining contract or collective bargaining agreement, contract, or statutory provisions providing otherwise, the employment relationship with the county is an at-will relationship.
That just goes back to what's on the cover page
Right.
and all the others, so it's just repeating it again, I guess that's fine.
Okay?
And repeat it every page in the book if you want.
Under policy, the recommendation is unless your employment is governed by a collective bargaining unit, blah, 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 so we'll keep that. The second paragraph, no written or oral representation by Iroquois County personnel other than a written contract duly approved by the county board will create a contract of employment. Okay, to keep that. The next paragraph, the recommendation is the Iroquois County's employment guidelines are intended only as an explanation of its employment practices, policies, benefits, and a general guide to working for Iroquois County. They do not represent contractual terms of employment. Now, she recommends striking out despite anything that the employee may read into any Iroquois County material, employment at Iroquois County is strictly at will, and adding in and are not intended to change the employee at will policy. So she's suggesting striking out the sentence despite anything that the employee may read into Iroquois County material.
And what is it she's adding?
She added in the sentence and are not intended to change the employment at will policy.
So that's adding on to the sentence before it.
Right.
Okay, that's what I was confused.
Well, I think that one's okay to keep. Is everybody okay with that?
I think so.
Alright, and last on that page. Okay, so under procedure, it currently states employees are required to sign an at-will employment acknowledgement form as a condition of employment. It is to be filed in the employee personnel file. The comment says, as stated above, not all employees are at will, so I would strike that sentence. Because you're covered above as it's stating, they are at-will employees if they are not under a collective bargaining agreement, contract, or statutory, whatever it said. Provision, thank you.
Okay.
So we okay with striking that sentence?
Well, I guess I understand what she's saying, but I wonder, does it accomplish anything for us to have an at-will employee sign a piece of paper like that? If you can modify that sentence to say at-will employees will be required to sign a statement
Mm-hmm.
acknowledging that they are at-will employees.
Okay, it's up to you.
Is that? I mean, she's saying that employees that are not at-will employees are supposed to sign it, and she's right, we don't want them to sign something like that. But I don't see anything, you see anything wrong with that, Myron, in having an at-will employee sign a statement acknowledging that they are an at-will employee?
I don't, actually.
I think that might be something that'd be worthwhile to have in there.
Yeah.
I mean, the contractual employees know that they're bound by a contract, so I don't see a problem.
I don't think we have very many at-will employees anyway. Charlie Hall.
Alright, so page 11, break time, no changes. 12, breastfeeding, no changes. 13, no changes. 14 is bulletin boards, no changes. Let's see here, page 15, business ethics, gratuities and loans. The comment here states the county is required by law to have an ethics ordinance. If it does not already have one, the Illinois Attorney General has prepared a model ordinance, and here is the link.
Do we have an ethics ordinance?
I believe so, passed in like the 90s, I think.
Is it worthwhile looking, if it was passed in the 90s, does it perhaps need to be updated?
I can pull it out of the file and we can look at it.
Maybe that'd be a good idea.
Okay, so there will be no changes here, but separately we'll look at the.
Well,
Sounds
is what we have in the manual here that we're not gonna change?
Yeah, she's just saying that we are required to have one, that if we don't,
Right, but I just wanna make sure that what we have here is in agreement with our ethics ordinance. There's
We don't know
no
until Brian-
contradictions.
yeah,
Right, we don't know, but we need to find out, that's.
Right.
my
I made note.
Yeah.
I made note. Alright, so 17 is, page 17, I should say, is computer, email, internet usage, and social networking. So under policy, she has added in, I'll just read everything together. So computers, computer files, the email system, software furnished to employees, added in cell phones and other technology resources, are the Iroquois County's property intended for business use. Employees shall not use a password, access a file, or retrieve any stored communication without authorization. To ensure compliance with this policy, computer, internet, email, phone, and other technology resource usage may be monitored. And then she added in, employees have no right to or expectation of privacy when using county-provided computers, computer files, email, internet access, cell phones, software, and other technology resources.
Sounds good.
Yeah,
And we do have everybody sign a computer use policy when they are hired.
okay, yeah, that
All
goes without saying.
So moving down,
And the rest of that's fine on that page?
yeah, that was the only suggestion. Page 19. No, back up, page 18. Alright, you can see on the bottom. On the bottom, where it says 1, 2, and 3, so number 2, she has crossed out organization and added in county, so using the county's time and resources for personal gain.
Okay.
And then the next page is page 19. Under number 5, sending or posting confidential material, trade secrets, or proprietary information outside of the cross-out organization, add in county. Number 8, crossing out organization, adding in county. Number 9, crossing out organization, adding in county. Let's see here, sorry.
12.
12, 16 and 18 are all the same, so we'll just keep those.
That's good.
Moving down, social networking. Iroquois County government herein after referred to as county, she crosses out and its customers. The county has adopted the following policy. Breach of this policy, crossing out will and including may, result in disciplinary action up to and including the termination of employment. She added in the sentence, only those employees or officials who have been specifically designated as county social media spokespersons are permitted to comment or post on social media on behalf of the county. Are you okay with that staying in there? So for example, the health department has a social media page, it should only be commented or posted on by their approved person.
Yeah,
So does that mean that if I wanted to post something on that page, or I had an opinion about something that was taking place there, that I could not do that?
Correct. You would have to go through their assigned social media person.
And if that person didn't wanna post it, then it wouldn't get posted.
Okay.
That's interesting, because I think there have been some violations of that policy. But I don't know that we've investigated it for.
Well, you have to look at on behalf of the county, so if you're personally making a comment on that health department's Facebook comment or page, that's on your own behalf, that's not on behalf of the county.
Well, that's.
That's how I read it anyways.
Well, but that's what I was getting at is,
I know.
How do you distinguish between the two?
Just stay off of it.
Under confidentiality and privacy, she added in the confidential information is information that is exempt from disclosure under section 7 or 7.5 of the Illinois Freedom of Information Act 5 ILCS 140-7, 5 ILCS 114, can't read that, 7.5, or which is prohibited from being disclosed under state and federal laws. So legalese, added in the legal language.
Yeah, I guess the problem or question I would have with that is that there are always incidents or examples or whatever you wanna call it down in Springfield where they amend and change some of these. Does that mean if we cite some of them here, that we have to have the responsibility to keep up with those changes and then go and incorporate into our manual? In other words, whatever, take one of the statutes that she's referencing, let's say that maybe the state, it ends it. And we still have it in our, or they expand it to, maybe the penalties to be greater or whatever the case might be. If we have it in here, then we have to have the responsibility to keep tabs on that and make the changes ourselves.
Now I read it as anytime there is a issue with confidentiality and privacy, we are to refer to the act, whether it's what it says now or what it says in 10 years. But I could be misinterpreting that.
I think it's just referencing the Freedom of Information Act and all of the statutes.
I mean, we.
Right. And if those
Yeah.
change, you don't need to specifically go back to this and say, hey,
No,
we're
but
gonna.
I mean, would it be appropriate if we added a clause, any future amendments or changes in those statutes would apply? Something, that's maybe not
That's
the
up to you.
exact wording, but something that would cover that.
Yeah.
The Freedom of Information Act is changed every few years.
Right, and it's not saying that, I'm reading it as you follow that as it is, and when it is changed, not, hey, we have, not adding in any other language stating that, you know.
Well, what you're saying is what I'm saying, should we have something in writing to cover?
I don't think so, because it basically says that,
I guess I disagree
but,
with you.
it's not my, John, it's not my decision, it's yours, so if you wanna add something in, we can add it in.
Well, to me, it would be clearer if something.
So what would you like to add in?
If you're talking about legalese and lawyer stuff, I think something would be appropriate to indicate that any further changes in those statutes would prevail.
So how do you want that written?
I don't know, I have to think about it for a while.
Confidential information is information that is exempt from disclosure under sections 7 or 7.5 of the Illinois Freedom of Information Act, and it states that, which is prohibited from being disclosed under state or federal laws.
I think that covers it, when you say or,
Mhm.
the or part there, John, just my interpretation of it, where it says or which is prohibited by being disclosed under state and federal, or federal law. So I would think that would, in my opinion, keep up with the changing, because whatever's disclosed by the state or the federal,
Right.
in my opinion.
Maybe there's,
You can think about it if you want, we can come back to it.
let's leave it at that and go on.
Sure.
We got a lot to try and get done here.
Alright, so where are we at here?
Not that big of a thing, it's just.
Page 21, subject is confidentiality, so under policy. Okay,
Backside of 19.
backside of 19. What? Did I?
Yeah.
No,
No, you didn't. That's page 20 then, right?
thanks Amanda, sorry about that, I skipped a page. Alright, so on the back of page 19, here I have it up on the board, it says, under the third paragraph, if a blogger or any other online participant posts inaccurate, accusatory or negative comment about the county or any of its employees, do not respond to the post. And the comment there stating employees do retain certain free speech rights, therefore I don't recommend a blanket ban on an employee's ability to respond. So she's saying strike that do not respond. And keep in notify your immediate supervisor who will communicate through the chain of command. So are we okay with striking that out?
What's the reason for not responding?
She's saying take out do not respond,
Why?
and the reason is because employees do retain certain free speech rights, even though they are employees. So she doesn't recommend a blanket ban. She recommends keeping in that notify the supervisor, but do not put in the don't respond, because then you're infringing on their freedom of speech.
That gets back to what we were talking about a few minutes ago, though, that in the first place, there's only certain individuals that are supposed to be authorized to respond or post anything on these websites.
Mm-hmm.
And then secondly,
This isn't on behalf of the county, what this is saying is if you are responding personally, you can't, she's not recommending keeping in that do not respond personally because it infringes on their free speech rights. However, instead of, they can respond, they can't respond, but keeping in that notifying your supervisor will keep the communication open through the command.
I don't know, to me, it's a little bit confusing.
Are we okay with taking out that do not respond?
I'm not so sure about that. What do you think, John?
Well, if we want, like I said, if you're responding on your own, in your own, page, that's one thing. If you're responding on the county's page, I think that's where do not respond to the post applies, because if we have taken, you're talking about the health department, they have an individual that's supposed to maintain that page or that site. They don't want other people responding to things on there. If there's something on there that I didn't like, or any one of us, we're not supposed to respond to that. We go talk to that person, talk about it, or whatever. But to me, it's in a sense, it's contradicting what's in here beforehand.
Well, beforehand is posting or anything on behalf of the county. This is specifically saying, if John Doe says, hey, the county treasurer gypped me $5, it doesn't want me personally as Jill Johnson saying, well, hey, I work for the county, da 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 da. I have the right to do that. However, what we had in here prior says, no, I don't want you to post at all. But if I was to post and there's repercussions, then it can come back thinking lawyer talk or whatever, that, yeah, I did have every right to do that because it was my personal account and I have the right to say whatever I think I should say. However, per our policy, we have it in here, do not respond to the post. So, I mean, it's up to you if you wanna keep it, if you don't.
Well, if you have somebody in the example that you're saying, if you have somebody that responds to the post, other people can take that as meaning this is the county's response to that.
Right,
And I think that's what we're trying to avoid, because
Right.
that's not, that one person is not speaking for the county.
yeah,
So,
I mean, I don't think it,
on that basis, I think it's probably better that it be kept in there.
well, and, yeah, I mean, personally, I don't think you leaving it in there, I agree with that, because, yeah, she's saying I don't recommend it, but if and when an occurrence happens, just so we're aware that we may not win that one, because they still do have the right of free speech. But, yeah, you could leave it in
We'll
there,
cross that bridge when we come to it.
exactly, you could leave it in there, it's not
I
gonna
say
hurt
leave it.
anybody.
You have any thoughts, Myron?
I'm not a big blogger. So, but,
No, some
I
things are pretty
understand
nasty.
what they're saying, but I also understand,
Right,
if you left it in there and somebody said something in there that was defamation, that's gonna be on them. So
mhm,
if they say false statements that, the county did this and you actually didn't do it, then they're actually hanging themselves. So I don't know that it would hurt to leave it in my
Right.
opinion.
I say leave it in.
okay, we'll leave it in.
I mean, to the extent that it would encourage somebody, which it does say there, to talk to the supervisor or whatever, I think that's really what the kind of behavior that we want, because I think that's the way it
Right.
hasn't just been shut off.
Yeah.
There's a
Right.
procedure to be followed whereby it can be responded to properly.
Right.
Yeah, we'll leave that in. Okay, so the next recommended, let's see here, what did she say? So she added in, the county may discipline employees for making a comment or posting any material that might otherwise cause damage to the county's reputation or bring it into disrepute. When employees' comments is made as a citizen and not as an employee and is made on a matter of public concern, the county may discipline the employee in situations where the interests of the county in promoting efficient operations outweigh the interests of the employee in commenting on such matters of public concern. Nothing in this policy shall be interpreted in a manner that unlawfully prohibits the right of employees to engage in protected, concerted activity under the Illinois Public Labor Relations Act. The county has and always will comply fully with obligations under the Illinois Public Labor Relations Act. Likewise, nothing in this policy shall be interpreted in a manner that unlawfully restricts an employee's rights under the federal or state constitutions. The county has and always will comply with federal and state law.
That's a mouthful.
It is a mouthful.
I guess as long as that doesn't contradict what we just decided
Right.
about leaving the do not respond or post, I guess it's fine to put that in there.
Okay, and then under responsibility, it states, it is the responsibility of employees. She crossed out with Iroquois County computer access to comply with this policy. So it is the responsibility of the employees to comply to this policy,
That means whether you have access to the computer or not.
right?
That probably makes sense.
Yeah.
Okay. Now we can move on to page 21. Alright, so. Okay, so under policy, she recommends adding in again that paragraph that states confidential information is information that is exempt from disclosure under section 7 or 7.5 of the Illinois Freedom of Information Act, or which is prohibited from being disclosed under state or federal law. If you have any questions on whether information is confidential, you should speak with your supervisor before releasing any information. Requests for records under the Freedom of Information Act should be immediately directed to blank as they are time sensitive, so the county board executive assistant. Are we okay with adding in that sentence?
Yeah.
Inquiries relating to confidential information should be directed to the department head or supervisor. Under responsibility, it is the responsibility of the department head or supervisor to ensure that all employees, and she added in, are aware of this policy and trained to recognize confidential records or information. Are we okay with that?
That was A,
That was A.
say it again, please.
It's just another way of saying.
It is the responsibility of the department head or supervisor to ensure that all employees are aware of this policy and trained to recognize confidential records or information.
Yeah.
B, it is the responsibility of the person designated to do general orientation to instruct all new employees regarding this policy and how to recognize confidential records and information.
Who is the person designated to do general orientation? That's somebody in each department? That's not Amanda?
Every
That was an
department's gonna have
interesting look
something
past
different
back.
as far as confidentiality, there's nothing in my office that can remain confidential,
Right,
so,
right. Now the health department will have separate
right.
stuff, so they do have their own guidelines as far as that goes.
So are there offices that have confidential information in?
We have confidential
State
information.
security, health department.
Yeah, we don't, Amanda and I don't just go around handing out social security
Yeah.
numbers.
I mean, even beyond that,
Yeah.
I've gotten mail from the state that's specifically confidential,
Yeah,
and it's been kept that way.
yeah, oh, yeah.
You can tell us now, John.
Alright, so under procedure, they added in the sentence, violations may result in disciplinary action up to and including termination. Are we okay with keeping that in?
Say it again, please.
Violations may result in disciplinary action up to and including termination.
Yeah,
Alright,
confidential
so
stuff.
let's see. Conflict of interest, let's see here. she recommends that the county incorporate the same policy as she attached whistleblower policy. I can print that off for everybody, cause I don't have that with us, so can we skip page 22 and I'll print it off?
We can consider stopping at this point if you want, it's almost 10:30.
It's up to you.
How long the committee wants to.
I'm here till 4:30, so it's up to you.
Yeah, let's go to 4:30.
You're only here till 4:30.
Well, usually I'm here till 5, but depends.
Order out pizza.
That's, I gotta pick up the kiddo
If you both.
before 5:30, so I'm here till 5.
Fine with me.
Okay,
Okay, so we're gonna
let's
stop.
bookmark where we're at and next month we'll resume.
We're on page 22, is that correct?
Yes. Right, and I will print the sample policy for next time.
I wanna try and encourage everybody to read on ahead and
I have already.
get a understanding of everything, and also try and keep the rest of the stuff on our agenda minimal so that we can devote as much time as possible to this, so we can get this thing done. Okay? So moving on, we will dispense with the executive session, we'll go to the appointments, which if any will be made at the board meeting. Correspondence, I just have one thing here. I don't even know what it is, I don't know if I maybe opened it up. From UCCI talks about they had a membership meeting on Monday of this week.
Well, we kind of missed out on that, didn't we?
Day late, $1 short.
Yeah.
That's all we have with that, we have some claims today. Has everybody seen the claims? If not, we can pass them around. We need to pass the claims around? Got it. That being the case, we have a motion to approve the claims and send them on to the board.
So moved.
Is there a second?
Second.
Second by Mrs. Lawful. Are there any questions about the claims? Seeing none, would you call the roll, Amanda?
Hollis,
Yes.
Barr,
Yes.
Awful,
Yes.
Sure.
Yes. Is there any old business to come before the committee this morning? Is there any new business? Is there a motion to adjourn? Mr. Rolfe, is there a second? Mr. Bard? All in favor say aye.
Aye.
Meeting is adjourned.